in relation to your question. Did you have anything that you wanted to kick off with, Mike?
Yes, I'd quite like to just ask a couple of questions or ask people's opinions on the IR35 announcement, but I can do that whenever you want.
I think maybe we should wait for Angie from Thomas Mansfield, because he has raised, is this about the Somerville case? The worker status of non-exec directors, is it linked to that?
No, it's to do with the Chancellor's statement on repealing the IR35.
Okay, that's fine.
And about that. So no, it wasn't specifically case related.
That's the case law. All right. Do you want to, okay, why don't you just ask the question? I mean, we could just talk about it.
Sure.
That's fine.
So I've read the Chancellor's statement, because that's the rock and roll lifestyle that I'm living now. And it's saying that they're repealing the IR35 rules that were introduced in 2017 and 2021 with effect from April 23. And I think my question was, I haven't quite got my head around, I think I understand it that it means it's taking the responsibility for the declaration of tax and national insurance away from the engaging entity and back to the consultant. But what I haven't quite got my head around is where I often get questions from clients saying, oh, we want to take this person on 40 hours a week with a company email address and a company laptop working in our office, but they're going to be a consultant, so they're not an employee. Whether or not my normal advice on that is likely to change, because I would have still thought there's a tax implication for the company there, but I don't know if the IR35 rules are likely to change that. And I just wanted to hear if anyone else had an opinion.
Hi, Faye.
Hi,
really
sorry I'm late.
with the,
No, it's fine. Just a quick capture for
Thank
you, Faye. We're just looking at IR35 based on the chance, Mike was saying how he's got the time to read the Chancellor's statement, and he's managed to go to the IR35 announcement. So we're just talking about that and how we're thinking
great.
going forward. All right, Roz, I'm sorry, go on.
yeah, no, I was just saying I haven't really got my had the chance to have a proper look at it. But if they have repealed it, then I guess what you've said is true in the sense that it falls to the individual to decide what their tax status is. But I agree with you in the sense that it just leaves employers or engaging entities open to potential issues with HMRC if the individual is saying, oh no, it's fine 40 hours a week having complete control because I've got this limited company. I still think that the HMRC are going to take a dim view. It seems a bit of a nonsense. Really, it's a bit. I think my advice would still be the same. I think if it looks like an employee, it's an employee, and that's how HMRC would see it.
Mike, I agree with Roz there. I agree with Roz on and two things from me. One, the example that you just gave, where somebody is working on your premises using your laptop. I mean, the very minimum there is worker status, if not employee, depending on. And again, you said 40 hours. That's 40 hours week after week. It's straight away an employee rather than a worker because there's consistency of hours there. But that aside, okay, that could be examined on a case-by-case basis. But I think the advice always has remained that this is the responsibility of the employer to establish the status. And if we don't do it, we are going to land in hot water. And the number of times we give that, we examine the historic relationship, and then we say this is either a worker or an employee, not a consultant. And of course, we get the response saying, I don't want to go on worker status. I don't want to go on the payroll. And then we just say, well, no, that's not for you to decide. That's not even for the employer to decide. It's historical data. And this is how we go with it. Otherwise, there's consequences for, now you're saying, as per the Chancellor statement, which I haven't read either, now you're saying it's not going to result in any kind of penalty for the individual. However, the employer is still not going to be absolved, I don't think, from responsibility.
I think it also creates so many blurred lines because there's always this disconnect between how HMRC might view it and how employment law might view it. Because if they're saying, oh, I'm a consultant, and you kind of say, oh, okay, and then something comes up and it all goes a bit sour, then, you know, potentially everything that the way that you have treated them, because you haven't treated them like an employee from an employment law perspective, is going to be wrong. And well, at least called into question. So there's this real, you know, it just doesn't, it's hard enough currently, but this would make it even harder, because it would just make no logical sense.
It would make it harder for the employer, I think, especially if the chancellor say no onus on the employee anymore. You got, you know, it would make it harder for an employer, I would think.
I'm curious. I think you're right. I'm curious what Chris and Faye, what you tend to advise your clients on, because I think, as Ros has alluded to, you've got the employment law issue on one side and the tax law and the tax implication on the other, and the two don't necessarily align.
I mean, we'll always kind of look at the true nature of the relationship and advise people it doesn't necessarily matter what you've got in your kind of written terms and conditions. Just because you've got a clause in the contract saying this isn't a contract of employment, that doesn't matter. The courts will always look at the true nature of the relationship. So we'll always be looking at kind of mutuality of obligation, all of the normal points that the courts will look at. I mean, from a tax perspective, we obviously don't get involved in the kind of nitty and gritty of that, but advise that obviously a lot of the time the clients don't want to take your advice because they don't want to, like you said earlier, Sandhya, they don't want to be viewed to be an employee or a worker. But we'll always be saying to them, look, this is the relationship that you've got. Yes, it might not be the answer that you're looking for, but we'll always focus on the employment law aspects of it and what the courts are likely to take into consideration.
I would agree entirely, Faye. I mean, I think that's right. There's always going to be a friction, and sometimes you can't dovetail comfortably the approach from the Inland Revenue and the sort of overarching employment law implications, because I think they generate from different areas. You know, the revenue are keen on maximising revenue streams for the government, and the tribunal are there primarily to implement the law, but also to protect employment rights to the extent that individuals have them. And of course, you can't contract out of statutory rights. I mean, you know, you either have or you don't have employment status. Normally it's that innominate term, isn't it? It's a hybrid situation where somebody's a worker. So you can recognize an employee, it's quite clear. You can recognize somebody who's self-employed because there's no exclusivity, there's no control, they're in business on their own account, all of those sorts of functions in terms of mutuality. But it's that one slap back down the middle, particularly they may be in business on their own account, but you give them a computer and they're working 3 days in your office. And it's not just a one-off, it is the continuum of that arrangement, and it's the duration which is likely to fix the implications of their status. If in doubt, from an employer's perspective, I think you're always wise to approach it that they have at least worker status, because that way you are looking at how you pay the tax treatment, things like holiday pay, any rolling up element, which, you know, obviously is frowned upon. You're much likely to be better informed if you approach it in a sort of deliberate manner that it's dangerous, and it could come back to bite you. I haven't seen the full detail. Like Ros said, I suspect that's, you know, yet to sort of really land. And I'm sort of quite happy to follow the articles that will no doubt be written about it and leave me better informed. But at the moment, I would be cautious.
I mean, I'm trying to remember back to I think it was 2017, the first bits of legislation, and then obviously April 2021 when the next lot came in. But I'm trying to think prior to that, it was always that the tax element was a completely separate discussion to the employment element. I actually had a situation.
I think sorry to cut you off, because I just had a thought. I think before 2017 it was there was this ability to have a get out, wasn't there, if you had a limited company? And it was just assumed, oh, you've got a limited company, that's fine then, doesn't matter. Everything else is irrelevant, almost, in terms of tax anyway. I think that's what they are going back to, is it?
I have to say, I don't remember it being that blunt. I always seem to remember it being a bit fudgy, but again, this is 5+ years ago. I had a situation with one client where they had kept someone, they had got rid of someone, then brought them back as a consultant. It then went pear-shaped in terms of the relationship. And the employee absolutely crucified them because it just kept saying, okay, I understand it hasn't worked out, so let's talk about redundancy pay. And by the way, can you just point me to where you've been making my NI contributions? And literally they went straight to HMRC and said they haven't been paying me properly, and they haven't been taking tax, and they haven't been taking NI contributions, which is why I can always recount that when I'm speaking to clients. Anyway.
Yeah.
This is the thing, Mark. I'm sorry, Chris, go on.
Sorry, Sandhya, I was going to say something of a dual-edged sword, isn't it? If you start threatening, because blackmail is deeply frowned upon generally in sort of nice circles, but secondly, so what can be a very forceful point can rebound somewhat because you stray from whistleblowing to pointing out the invalidity of the arrangement if you knew full well that actually it was fraudulent, and you can't enforce a fraudulent contract. So you see people who sort of tiptoe all over those lines and cross recross and so forth. Certainly my experience, Ros, was similar to yours. I don't remember the date, to be absolutely honest. If it was
no, I don't.
17, to be honest, but it was certainly a point where you regularly saw the tripartite arrangement. So you had the employer, nominated individual, their company, and the contractual arrangement encompassed all three. But clearly, the arrangement was the individual was going to be servicing the company. So, and I think that partly my understanding of the IR35 was to give that sort of purposive interpretation that if it looked like a worker, that sort of arrangement that people would understand as a more direct link, that it ought to be taxed as such, and the umbrella and the status and the paper trail and all the rest of it's all very nice, but that was just one factor that would be looked at. It was very much more intended to be realistic. So, but I say I have yet to see any real articles on it.
Yeah.
I think in a nutshell, though, the more we're speaking, it seems clearer, Mike, that even though the Chancellor has said, it's not on the onus is not on the individual anymore to just sort of decide which side of the fence they're going to be on. As far as an employer is concerned, and as far as employment law is concerned, we still have to worry about the status of employee, worker, contractor. That hasn't changed. And equally, as far as HMRC is concerned, they are just binary. It's only binary. It's only, you're either an employee or a consultant.
I'm not. Let me just. Sorry, I won't take this up, but I don't think that is necessarily the case. I think it's. I think
with workers, they can be paid either way, and it really depends on the nuts and bolts of the relationship. But we're getting into tax law now, which is definitely not my area of expertise.
A worker, they go on the payroll. That is where I think the individuals have an issue, because they only understand it from the perspective of HMRC laws, where they say, oh, it's either I'm paying tax rate for a consultant or I'm paying tax rate for an employee, which is why the minute we say your worker status, they don't like it, because they know they're going on the payroll, and that's going to impact their tax rates. So when we identify somebody as a worker, they automatically go on the payroll.
I mean, I'll look it out, but I think the link that I was just reading in terms of on the government announcement, it was very much saying it is no longer the company obligation to determine the status. Anyway,
Mike,
sorry,
Mike.
okay, I'm sorry, I'm diverting everyone down a rabbit hole. I'll sorry.
Mike,
if I find the link.
One thing I was going to say, Mike, is I would imagine this has a start date, and they haven't just flicked a switch, and
Correct.
most of these
April.
things seem to be April. So that again,
we've got time.
there may be time for all of us to sort of look at that, and there may be wider implications. But I certainly for the time being, I don't think anything's changing.
Yeah, I think there's a lot of civil servants that are going to be scratching their heads going, oh, how's this going to work in practice?
I'm not dreading all this
now in
time,
April.
but I'm dreading the clients are going to come back and say, oh, you said worker agreement and now that's not required anymore. Where do they stand now?
Yeah,
I've decided I'm going to change I'm going to set up Feeman Consulting with a specialist branch for companies doing IR35 webinars for the next 6 months, because I think that's a growth area. That's my growth plan suggestion.
Yeah.
Well, sign me up, Mike. I'll be very happy.
We'll all come.
Chris, don't worry. As usual, I will be leading things with no personal knowledge myself. I'll just sound knowledgeable.
Refer to your knowledge of your expert colleague.
Exactly, my expert colleague who will be named in due course. Yeah. Yeah, here we go. It says, from this date, workers across the UK providing their services via an intermediary, such as a personal service company, will once again be responsible for determining their employment status and paying the appropriate amount of tax and NICs. So it is moving it away from the company back to the contractor.
I like quasi-quartering even less now.
What do you mean? It keeps all of us lot busy.
I don't want to do that though, it's too complicated.
And the thing is, it's taken everyone so long to kind of get their heads around IR35 and how it's going to operate, and then now all of a sudden it's like, oh yeah, we're going to scrap that. Yeah, forget everything that you've been trying to get your head around for the past couple of years or past year.
All the ground that we've made trying to persuade employers to do the right thing and just take sensible decisions, we've just gone, yeah, you don't need to do that anymore.
Yeah, forget that.
I'm sure if the government say that one of the benefits of this change is that it will keep HR people and lawyers in business, that will get a lot of public support. So I think we'll be fine.
Okay.
Sandhya, sorry, I took down the IR35 rabbit hole. Sorry.
No, that's useful. I think now we will surely invest the time to read it, Mike. You've started this discussion. Oh well, right. Moving on from there, Rose, you had a question about representation.
You know, I remember I asked a question. I can't remember what it was.
Representation for an individual with mental health issues.
Hang
on, I'm just trying to go through. Yeah, legal companions at internal processes.
Yeah.
Where there is a disability, specifically mental. So I understood that as legal union representation.
So it's kind of been resolved now, and it was it was a misunderstanding, I think, of the situation. But essentially, it was a situation where there was an employee who had cognitive restrictions, let's say, because of an injury that he sustained many years ago, and he was subject to a disciplinary process, and he'd already had a warning, he'd had a final warning, and so even if the outcome wasn't gross misconduct, it would have been a procedural dismissal. And the company started getting correspondence from a lawyer saying, oh, we need to delay because we need to provide advice to Mr. X and make sure that he is supported properly at his disciplinary meeting, at which point we were like, well, I mean, they delayed it by 2 weeks already on request. And so it was just that whole kind of thing about how far the obligations to allow legal intervention, I suppose, and potentially a legal representative attending the disciplinary meeting, how far that goes. It's a bit of it is all dependent on the circumstances, but it was just, I just thought that maybe it would be good to draw on any experiences and any advice from the legal professionals about how to apply that, because there is some leeway, isn't there?
Yes. So shall I give an initial view and kick it off? What a thorny question. Yes, very difficult, I would imagine. If whether or not the individual has 2 years service for unfair dismissal purposes, I think you'd approach it as an unexploded bomb in terms of any discrimination, or at least associative one. So it would be incumbent, I think, on the employer to follow a very fair and reasonable process. I would lean over backwards sort of approach. I don't think necessarily that would go so far as to extending the companionship to legal representation in the actual process itself in terms of attending meetings. I would draw a line at that, because I think the law doesn't go that far, provided that they had a sensible companion or trade union.
Yeah, I mean, he's previously taken his mother because she understands his illness.
I was going to say, extending it perhaps to a wider circle to friends and family is always, providing again they're not trained lawyers, is I think a very friendly, overtly reasonable thing to do. And I think that works both ways, because it actually makes, if it makes the actual process itself more reasonable, it's much more likely to end in a reasonable outcome, one that can't be challenged, at least on procedural irregularity. The main thing, I suppose, is always to make sure the individual understands the process that's been followed, the case have to meet matters of natural justice, and they have the capacity to actually deal with that. So whatever support gets you to that point, I suppose.
I mean, that was our view, but I think that, you know, in terms of the law, when I spoke to somebody, I just picked up the phone to ACAS and said, you know, we want to do the right thing, but, you know, and they basically said, well, it would only be determined in a tribunal as to whether you had been lawful or not. And I thought, well, we don't really want to go that far.
Yeah, thanks for that. You know,
yeah, thanks. That's I'm glad it was free.
Ros, in the company it happened, did they have, I don't know whether it was a big or small business, but did they have mental health first aiders?
That's a good question. I'm not entirely sure, to be honest with you, because I was doing the work as an associate for another consultancy, so I was drawn in at various points to try and support, but then it was led by another consultant in the end, who knows the client better than I do, so I'm not entirely sure. I'd be surprised if they didn't, because she's been working with them for quite a long time and kicking them into shape, and he had been treated extremely fairly, and just many adjustments had been made to enable him to work at the castle. So he wasn't employed at the castle before he was injured, so they took him on in full knowledge of all the difficulties that he would have, and I think actually, although he did have restrictions and needed structure and all the rest of it, he was very capable mentally in certain aspects. There were just certain things that he couldn't cope with. So I think it was just the idea. So the manager that was going to hold the disciplinary was kind of like, well, I don't have a lawyer in the room with me to guide me with what I'm doing, and I don't want to, because it's an internal process. So she felt a bit kind of, I suppose, uncomfortable with the fact that there would be an employment lawyer in the room that was supporting him if she wasn't given the same, you know, in the same situation. She would have a consultant with her, but not an employment lawyer. So yeah.
Ros, with again, because you were working with this individual as part of another consulting firm, I'd also look at policies, because sometimes we just make it very clear in a policy that as to who could be a companion, who could be a representation of these internal processes. And it's usually
I think it just
family.
said the usual things that it would say. You know, there was no trade, you know, just a trade union rep or colleague, you know. So there was nothing immediate. So it would have been we were making an adjustment to the process in order to support you because we recognise you have a disability. Previously we had allowed you to attend with your mother. Why is that not okay now, given it's an internal process and we're not in a legal setting? So it was more that kind of
And I completely agree, and I think we'd always kind of make the individual aware that actually their statutory right is a colleague or a trade union representative, but in an effort to make adjustments for you, we're willing to extend that, but you've got to draw the line somewhere, and we'd certainly draw the line at having legal representation there.
Same here.
I know when I speak to clients, because our clients sometimes ask me the same thing, and I say, you know, generally not lawyers, but the question I normally ask a client who says, you know, well, I've been asked for this, is I say to the client, what outcome do you want? And if the answer is, okay, let's be honest, I want to get rid of them, that's a different discussion. Then it's a different discussion to, actually, I really want to try and make this work. Because if it's the latter, then I say, well, then you probably should need to go further, because if you're trying to make it work and you don't quite understand why a medical condition of XYZ is going to affect their work, then you want to try and understand it. So if you can get additional help in that, that's useful. If your end goal is you really don't care and you want them out, then you stick to the rules.
There's no benefit to having the lawyer there. There might be a benefit if you wanted to stick with it. That was a fair point, Mike. Actually, I never thought of it that way.
Although having said that, there is the other thing. I have also at a couple of times done a thing where I have suggested letting a lawyer in, and we've had them in, and you know, we've been pretty certain of our position, and in effect, in that circumstance, it worked quite well because the lawyer kind of tried to take over the meeting, and we just let them, you know, run with it, and then you know, then just said, well, this isn't for you to say, and they kind of exhausted all of their arguments at that point. I mean, it was a risky strategy and not one I'd employ at the time.
Okay, thanks for that.
It is just that again, that how far you want to be seen, the perception of being utterly reasonable, because it is, we are talking about a right to companionship or to be accompanied, sorry, let's be precise, rather than be represented. And so if you choose to let somebody have a representative there and give them some space and allow them to speak, that's absolutely fine. But of course, you've got the usual points where they can't answer direct questions. So it can play a useful part if you engage with them, you listen to the rationale, the points they're putting forward. You're better informed when you come to reach a decision, because you've taken those points on board. And certainly you can say, you know, we've approached it with an open mind, we've listened to the points that have been advanced, and either we've taken that to heart and you know, in this particular instance, we're going to make this decision, or thank you very much, it's made not a jot of difference. You know, we're going down this path, but either way, you can't be criticized for having listened, and sometimes you're better informed for having those points. But I don't think you should be criticized as an employer, as you say, from moving away from what is an internal process and letting somebody attempt to hijack it. I think there's nothing wrong with saying no, you know, that's not permitted either under the company policy or indeed statutorily. You do not have that fundamental right. It is a matter for the employer's indulgence or discretion.
So.
Interesting. If it's fine with everyone, I've got a situation that I'd like to ask a question about. So this is something where a business has approached me because 2 years ago the employee continues to work for the business. 2 years ago, the lady raised complaints around discrimination, and it was going all the way up to the CEO. And she said she doesn't want to raise a grievance at the time, but she raised these concerns. And when the business asked her, you know, what she wants as an outcome, she said, I don't want to raise a grievance, but I just want to make you aware that this is how it feels. And at the time, 2 years ago, nothing was done, and there was no sort of investigation carried out. Nothing happened. Finally, it has to, you know, she's raised this issue again, and she's saying that it's even hindering. She's not being given equal opportunities at work, even for promotion or putting herself forward for jobs. She feels quite strongly about it. And this is where the business has now approached me saying this has come up again. She again doesn't want to raise this as a grievance because now she's going through quite a acrimonious divorce, and the stress levels are pretty high, and she doesn't want to delve through the grievance procedure where what is our obligation, you know, should be heard as a grievance. And she's continuing to name, of course, other staff members and the CEO. It'd just be good to have your insight on it. My leaning is the problem's festering. She's raising it, you know, as again. And discrimination is quite a serious thing where she's naming individuals within the company who are senior and her colleagues. And I just think it needs, people don't have to mention it as a grievance. You still got to take it on.
Yeah. Yeah. And I think
that's my take.
Yeah, I think I agree. Like you said, I mean, if I'm ever acting for an individual and they come to me and they say, oh, I don't really know where I stand because I didn't raise a grievance, we would always be saying that just because something isn't labelled as a grievance doesn't mean it shouldn't be treated as one. And I think especially if they are raising kind of serious concerns going all the way up through the company, yeah, I think it's something that needs to be investigated to kind of mitigate the risk of any future litigation.
Yeah,
yeah, I think it's a conversation with her to say, I appreciate you don't want to go through the grievance process, but we have an obligation to investigate any of the allegations of this type to make sure that we are acting responsibly and fulfilling our obligations to you and all the other employees. So this is what we're going to do, I guess kind of take it out of her hands, as it were.
Yeah.
Sorry, there's another thing.
She can be involved as much as she wants to. Go on.
On that point that you raised, I was reminded of this. She also, because of what you said just now, she's also added that if the business is going to hear it as a grievance, I'm going to raise charges of bullying harassment. And you think, really?
Well, then I think the decision is made, isn't it? You have to deal with it. You can't ignore that, because this is what irritates me when people say, oh, I don't want anything done. I just want it put on my file, because then they can use it against you, right?
Exactly that.
It just was a bit interesting for me, because there was another situation, again, going back a year, where an individual had raised a grievance, didn't want it to be dealt with, but we dealt with it, and it kind of carried on. And there was something to do with, it kind of linked in with some data disclosure. So, and she had just found basically paperwork lying to the dentist office and confidential papers just lying around, staff papers lying around where she just at the entrance of the toilet. So all that came up, and it was getting quite serious, some of the disclosures. And she got really uncomfortable, and suddenly she said, I'm withdrawing my grievance. We were midway through the investigation, and she said, I'm just withdrawing my grievance. And that kind of left me high and dry. And I kind of floated the question. Then the roundtable was not there, it was a different group. And I just floated the question, and the consensus there was, well, if somebody's decided to withdraw a grievance midway through an investigation, you can't force them. You've just got to conclude it based on the evidence that's available so far. So in this situation, I'm wondering, this individual is refusing to give any further information. We have said we're just going to crack on with an investigation based on available information. But given the serious allegations she's made, and so far the disclosures we've got some WhatsApp text messages, etc., but not much. She's not going to sit across us and have a chat as of now. Where does that leave us? So would we just run with the investigation just based on available information, and if she's not going to engage with the investigation, we would just make a note of that and conclusions would be made? Is that how we do it?
I guess so. She's refusing to meet with you so that you can find out exactly what's gone on. Then you can't force her to take part in an investigation.
But it's also very difficult to use information that she's given if she has said to you, if she has given information that would make her identifiable.
Mm.
I think that's absolutely the point, because if you can't rely on the cogency of the evidence you've been given, and you no longer have permission to use it, so you can't adduce it in terms of any investigation, you're stuffed. So in terms of her grievance, for whatever reason, as long as she's sat down and somebody's competent asks her just to explain it, so that it is quite clear she's not been lent on, there's been no further duress or intimidation or anything like that, bullying, because the alternative spin would be to say, look, if you choose not to raise it and pursue a grievance, okay, well, we can do that. The corollary point is you can't rely upon any points after a certain timescale, because the usual limitation for discrimination would apply. So we're putting a very firm marker down. So you need to be informed about that. Go away and think about it. But the further point, I guess, would be to offer the opportunity to run it as a whistleblowing case, because what she's complaining about, it seems to me, is unlawful conduct and unethical conduct, which could be investigated under a whistleblowing policy, which could be then anonymous. In which case, you've got all the usual difficulties. How do you do that? When you're identifying somebody, when perhaps you aren't necessarily going to identify who it's likely to be, who the complainant is, because of how the circumstances have arisen. But at least that might be an extra avenue you could explore with them to show you're giving maximum support, you are taking it seriously.
True.
And if they still say, no, this is dead, I don't want this taken any further, then at least you can't be criticized, it seems to me.
Yeah.
Because I don't think you're on any higher. I mean, it depends what but if somebody says, no, I do not want you to take this any further, and in fact you mustn't, and you must not
Exactly. Yeah.
identify me in any shape or form.
Here.
Although unless if something they have flagged to you is illegal, so take it to a sort of an extreme example, someone who's saying, I don't want this to be raised, I'll be identified, but it's money laundering, or but it's I don't know, something else like that, then obviously you're then straying into completely different territory.
Yeah. This is the thing, we don't, what she said is the processes are such that I'm not able to put myself forward for promotions or, job interviews fairly. And, it's just not, processes are just not fair within the business. And there's no issues about her performance whatsoever. She's apparently a good performer. So yeah, there's limited information at the moment.
So is it her actively saying that, sorry to interrupt, is it her actively saying that she's making the decision not to put herself forward for promotion? It's not as if she's kind of gone for the promotions and she hasn't been successful. So she's kind of predetermining the outcome of any process.
No, she's, again, I would have a better understanding of this if I can speak with her. For now, she's saying that the processes are just not fair. It doesn't allow me to put myself forward for a fair selection process.
Right.
So again, unless I scrutinize that as to what she means by that.
Yeah, it's really difficult.
Well, I could just based on that statement, I suppose I could look at some of the adverts and some of the ways they've been going about, interviewing and recruiting for people in the recent past. But yeah, she has repeated her complaint from apparently 2 years ago to say it is very discriminatory. The practice is just all pervasive within the business, it's from top down and across. But what she has said is she doesn't feel comfortable raising it as a grievance now and sitting across or being part of an investigation currently. She will do it when things are a little calmer on the personal front. But again, as a business, we need to figure out how to deal with this information.
Yeah, I don't think she should be able to sit on the fence, and I'm not unsympathetic to the individual's position.
I agree.
But you can't keep referring to something that you didn't pursue 2 years ago. I mean, to me, that's dead. I appreciate you can have a series of incidents that cumulatively get to the last straw, even though they may be outside a sort of 3-year repetition, 3-month repetition. But I think, that's dangerous. I think that should be squashed,
Yeah.
because say, no, I'm sorry, that is gone.
Mm.
If you know that's a historic point.
But Chris, I think you're absolutely right. But the practicality of that is, if the question comes, did the employee raise this with you? Yes, but they asked us not to do anything with it. When did they raise it? 2 years ago, right? What did you do about it? Well, we couldn't do anything because of that. And if you've taken no other action other than, oh, we just kept our eyes open, then the danger is that it chips away at the defence that this isn't a hostile environment. And I'm not saying there's an easy answer to it. All I'm saying is I think they raised it but asked us not to do anything with it because we couldn't use the information. Then I think, isn't there an argument to say, well, what else did you try to do whilst respecting the individual's privacy? And if you had taken no other action at all.
I think that's right. I mean, you always have that sort of that balance, don't you? But if you show that you took action which was appropriate, cooperative, that you tried to support, that you offered them counselling, that you went back with purposive and positive solutions. You know, if you like, you put a range of options and said, look, we can do this, we can do that, we can do the other. How can we best support you? What would you want to do? If the individual says, no, none of the above, then I think you're entitled to say, right, in that case, I'm sorry, because you can't now criticize us because we were responsive. We were, you know, we genuinely tried to be on the front foot here and deal with it for you. But now I'm sorry, you can't refer to that, certainly not in a negative way. And I would see the point, but I think you could, the corollary issue is you can say, this is a person who has historically made accusations and not been prepared to substantiate them or carry them through. So as an organization, we are trying to be positive and responsive, but we're unable to respond. And unless in the sort of categories you are describing, then I think you have an overarching duty. And literally, if you could see something really, really badly going wrong, I think you'd step in for health and safety or something, you know, or something.
Yeah. Which, like I said, I can't see right now because they're not it's new clients. I can't see, but I think I'll have to just find out a little more, even based on just what she's shared so far. Not even going back 2 years ago, basically what triggered it this time, what has triggered it now. Just looking at that recent data. But no, I think the whistleblowing option is a good one, Chris. I'll bear that in mind.
It's just because it's such a catch-all. I mean, whatever it is, I forget now. It's 6 categories, but that general one, the breach of a legal obligation, and in an employment context, is that a statutory one? Is it a contractual one? Is it a wider one in terms of preserving mutual trust and confidence? Is it an implied contractual duty? It gives you quite a degree of latitude from both sides.
Yeah, no, very interesting. Thank you. Thanks for that. I think we don't have any other questions, unless say you've got any questions, or Chris, you've got questions.
No, I think I briefly spoke to, so my colleague Sarah was meant to be attending in my place, but we had a switch around. I think she did submit a question, but I don't know what it was. I think it might have been to do with the announcement.
Sorry. Sarah.
Have you got it there?
Retained EU law, it's the Revocation and Reform Bill. Has anyone heard on the grapevine what EU laws might be retained before they're automatically repealed on 31st December 2023? Yeah, that's the interesting one. That's the next hot topic besides IRA, isn't it now?
Yeah.
Anyone want to do a take on that?
Both Sandhya and I are in a different group for HR people, and there's a webinar on that tomorrow. So feedback on that another time.
You can share that if you want to stay, but this is why I wasn't able to answer it, because it's tomorrow at 2 o'clock. So,
that'd be interesting.
But I think the short answer, we've already had a short answer to that, saying do nothing yet.
Yeah.
So who knows? It's a bit like how Chris was saying, do nothing, basically.
Yeah. Sit tight.
If in doubt, masterful
yeah.
inactivity.
Absolutely.
I
All
mean,
these changes coming in.
I had this discussion with
Just when you get your
someone.
head around something. Go on, Mike, you go on.
I had this discussion with someone a few years ago, and this was not in the context of Brexit or repealing laws or anything like that. But I said, I'm trying to think back over the last 30 years that I've been doing HR, where we have in effect rolled back on employment rights. And I can't remember a single time other than, sorry, the only one that I can remember is when the Conservative government came in 2010. They changed the time, the 1 year, it used to be 1 year for unfair dismissal rights, the Labour government to 2 years. But other than that, I can't remember a single time, but I'm looking to the legal experts on the call to see if they think differently. But to me, it seems like a political headline, but I'm not convinced underneath which way they're going to go, simply because we've never seen that sort of direction. Having said that, I think there is more chance of it happening now with the current incumbents than I think we've had in the last 30 years. So I don't know if Chris or Faye, if you can correct me on my memory on the direction of more protections rather than fewer protections.
I mean, I can't see us being in a position where protections are taken away from people. It just seems so, I just can't imagine us being in that position. I just don't know how, just the kind of upheaval that it would cause if suddenly protections are taken away from people. I just don't know I can't see a way in practice as to how that would be implemented without serious upheaval. I don't see that happening.
It would give the unions even more ammunition.
Yeah,
and
absolutely.
We've had quite a, it's bad enough as it is. So I would hope that the government wouldn't want to go there.
Yeah, exactly that. I mean, everything at the moment is just so unpredictable, though, isn't it? You just don't know what's going to happen next.
I would think that's right. I mean, it would be dangerously aggressive politically. I would have thought a real hot potato in that sense. I can see them not quietly shelving a lot of the recommendations and the route of travel, such as sort of legislating for further discrimination protection on say menopausal conditions or breastfeeding or something like that. I can see not wanting to enlarge the position and leaving some extent unclear and saying, well, look, the law's there, you just have to make use of whatever's there. But I would be very surprised if we actually slashed and burned and sort of went back, either to the dark ages or sort of stepped down 2 or 3 years. It seems very sort of counterintuitive. But I think it would be.
But discrimination law wasn't EU law. That was UK law, wasn't it? I think we're thinking about things like, I think there's more chance of things like the Working Time Directive being reversed.
And we've got 2P, the Working Time Directive. Yeah, and I think annual leave, anything to do with annual leave.
Annual leave.
I mean, I think annual leave.
Again, it's more private sector that's more impacted by it. I mean, it's more public sector that's impacted by it, right? The private sector can still have a little bit of leeway on whether they want to sort of offer more. The public sector are kind of more bound by that, isn't it?
I'm not sure.
I mean, I think the public sector go, in my experience, over and above the statutory requirements anyway. So they just be, they're not going to change that just because the law changes. Because they've, traditionally they've always been more generous. Like, some people having 30 days holiday and things like that, excluding bank holidays.
I mean, to me, the obvious one, if they're going to try and do something, is the working time directive, on the basis that it doesn't apply to the majority. But then you get into the discussion around lorry drivers and doctors and all the rest of it, and then I think it comes down to a political point rather than a legal point.
I think that's always interesting, because the genesis of the working time was health and safety, wasn't it? That was how it was introduced, rather than employment. And as soon as you get into either lorry drivers or doctors, you know, either spectrum or carers, where their working time is by sort of 9 to 5 standards considerably stretched. You do understand the rationale for having some measurement of that and some remuneration according to that, and of course some protection in breach of certain rights. It's a societal point. It's makes a lot of sense for public policy reasons to have some marshalling of that. I say I don't know whether the government really does intend to sort of remove a lot of these protections. And it's one thing, I think, to not introduce further legislation. I think it's another thing to go back a stage. I think that you know, is one is generally dressed up in there's not enough parliamentary time to give this full consideration that it warrants and so forth, but we are taking it seriously and just quietly bearing it. And the other one is really very confrontational, isn't it? You know, slashing rights.
I have to watch this
Interesting.
space.
Yeah, 2 points raised today, so thanks to Mike for that, and thanks to say your colleague Sarah. Yeah, but once we get
back to her,
any more clarity, if we get any more clarification tomorrow, say Mike and I can just put something together and share it with you guys.
Yeah, that'd be really interesting. Thank you.
Yeah,
we can do that. Lovely, good to see everyone.
Yes,
That
and
brings
you.
another roundtable.
you too.
And see you around.
Thanks, Sandhya.
Yeah.
Thank you. I'll
Thanks,
see you all
Sandhya.
soon.
Bye,
Bye-bye.
everyone.
Bye.
Bye.